The Fifth Circuit handed down an opinion with an important warning to legislatures in the oil patch. Here is essentially what the Fifth Circuit said. If a bankruptcy court in Delaware makes a ruling about oil and gas law, the legislatures in the oil patch should not ignore those decisions, perhaps on the theory that judges in Delaware don't know anything about oil and gas law. Well, the Texas legislature didn't act after a warning, some 12 years ago, with untoward results for producers in that state. As background, of course, the legislatures in the oil patch want to be for sure that producers in their states get paid no matter what, in bankruptcy or otherwise. What they want to happen is to be sure that the producers have liens on not only the petroleum that they sell, but also on accounts receivable and proceeds, because otherwise, if they don't, a producer who hasn't been paid by the time of bankruptcy is going to get cut off because the accounts receivable and the inventory and the proceeds will all go to the secured lender. Well, the state of Oklahoma had a bad result back in 2009 because that state, just like Texas, had put a special provision in the Uniform Commercial Code giving oil and gas producers a lien that did not ever have to be recorded. But in 2009, the bankruptcy court in Delaware ruled that no, it didn't work. That non-uniform UCC provision did not help and did not give the producer a valid security interest under the circumstances of that case. Well, guess what? Oklahoma pretty quickly amended its law, and in this decision in the last week, the Fifth Circuit held that yes, producers in Oklahoma now have valid security interests that prime the bank. But guess what? Texas had the same non-uniform UCC provision as Oklahoma, but the Texas legislature did not amend its law. As a result, the Fifth Circuit ruled that the producers in Texas in this bankruptcy case did not have liens at all, and certainly therefore lost out because the bank glommed everything. Indeed, the opinion by Circuit Judge Jones said that the Texas legislature needs to take notice, and she very politely suggested that the legislature ought to amend its law and perhaps copy what they did in Oklahoma. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe, stay home. See you next week. Good day.